Hello, secure transaction students. It's good to see you all, if only through video. I will be back in class with you guys next week, so I look forward to that. But in the meantime, we're going to get to the next set of problems here. And thank you all for getting your problems in, your outlines. I've been impressed by the way that you're handling the material and digging into the material and figuring it out. There's really no substitute for just engaging with that code and reading Article 9 and trying to apply it to the problem. So you guys have really been great about that. And today we're getting into the question of perfection. We've talked about the creation of a security interest, the attachment of the security interest, and those three indispensable elements of attachment. That value is given, debtor has rights in the collateral, and there's an authenticated security agreement. Now we're going to get on to perfection. And the first type of perfection that we're talking about is that most ancient method of perfection, which is by possession. And in some ways it's the ultimate form of perfection in that the secured party has control over the collateral and can make sure it doesn't get damaged or make sure it doesn't get sold or worn out through use. But of course, perfection by possession is not feasible when the debtor needs the collateral in order to operate its business. For example, it needs factory equipment or it needs inventory. Then you don't want to take possession of the material, and you can perfect in other ways, such as by filing a financing statement. But it is possible to perfect by possession under 9.313A. Take a good look at that, and you should know the 5 types of collateral that can be perfected by possession. And they're ones that, in some respects, it's intuitive. Goods, for example. Goods you can hold, you can actually possess in a physical sense, and so it's possible to perfect a security interest in goods by possession. But there are other types of collateral. Negotiable documents, that is a warehouse receipt or a bill of lading, a document that gives the bearer the right to the goods that are in a warehouse or on a ship or a truck. Negotiable documents. Those can be perfected just by possession of the document. Goods, instruments, that is promissory notes for the most part, can be perfected by possession. Money, cash, can only be perfected by possession. I've mentioned that before. And then tangible chattel paper. That is an obligation to pay for the sale of goods, for example, coupled with a security interest. It's the most typical type of tangible chattel paper. So know those 5 categories. Those you can possess and perfect by possession. Now let's get into problem 43. I'll read it. Your client, Archibald Gracie, owns the White Star of England, a famous diamond, currently on display at the Astor Museum in New York. Now Molly Brown, a wealthy Colorado investor, has agreed to buy the diamond from Gracie, and she made a substantial down payment with an agreement to make 3 more payments before she gets possession. Okay, so this is an installment sales agreement. Gracie and Brown have signed the purchase agreement, which contains a clause granting him a security interest in his own diamond until Molly has made all of the required payments. Okay, very good. And his question to you as lawyer is this. Can he perfect a security interest in the diamond by simply notifying the Astor Museum of the sale and telling the museum to hold it for his benefit until she, the buyer, makes payment in full, thus creating an escrow arrangement? Okay, and the answer to that is no. Just notifying the museum is not enough. There are 2 ways. The question here is if you have something short of actual possession by the secured party, by Archibald here. If Archibald doesn't have possession of the diamond, can a third party, the museum, have possession on his behalf, and therefore will it be treated as perfection by possession? And there are 2 approaches to that. There are 2 ways of getting to a yes in that case. One is if the museum is an agent of Archibald, and that goes to common law of agency. And typically you would be an agent if, for example, the third party were an employee. But here the museum is not an employee of Archibald, it's not an agent of Archibald. and so we can't get constructive possession that way. The other way to do it is by having the museum authenticate a record, sign a document saying I'm holding the diamond on behalf of Archibald Gracie, and then you might go further by saying I hold possession of the diamond in order to perfect the Archibald Gracie's security interest by possession, by holding it on his behalf. If you have an authenticated record like that, that is permitted under 9.313. But we don't have that in this case. All we have is Archibald notifying the museum, and that's not enough. So the answer is no. Problem 44. Kitty Delight, a manufacturer of toys, wants to borrow money and use its inventory of toys as collateral, so it calls up Fred's Field Warehouse Company, and Fred comes to the plant, puts the inventory in a locked room, posts a sign on the door saying contents of room under control of Fred's Field Warehouse. And then Fred issues a negotiable warehouse receipt, deliverable to the order of Kitty Delight. Fred's hired Mort Menial, the Kitty Delight janitor, as its local warehouse custodian, pays him $1 a week, but otherwise he gets his paycheck from Kitty Delight as usual. And Kitty Delight pledges the warehouse receipt, which is a document, in the parlance of Article 9, to Mammon State Bank in return for a loan, and then Kitty Delight goes bankrupt. So you see what happens here. A Field Warehouse Company comes in, it gets control over the goods, puts them in a warehousing situation. Sometimes it can be a locked room. They could, in other situations, they can construct a chain link fence around certain collateral and lock it, creating a warehouse. And then the warehousing company issues the document, the warehouse receipt. And then the owner of those goods can use that document as a proxy for the goods itself. It can take that document and pledge it as collateral to a bank. And then the bank can enforce its security interest against that document by selling it to some other party, to some third party, who would then come into possession of this negotiable document and would be able to access the goods. So this document is just a proxy, stands in place of the goods, and you can use it as collateral. And the question here is A, by having possession of this document, did the bank have a perfected security interest in the inventory? And yes, he delivered possession of it, and under 9.313A, you can perfect a security interest in documents, like a warehouse receipt, by possession. There is some question that's raised here. If you look at 9.312C, it says that goods in possession of the bailee can be perfected by security interest in a document. And so that phrase, goods in possession of bailee, that's a factual question that's raised in this fact scenario because the custodian, the warehouse custodian, is actually an employee of the debtor, and is just paid $1 a week by the field warehouse. So there's a question that could be challenged in court about whether this warehouse actually does have control and possession over the goods. But let's not make too much of that. What I want you to do is come away with the rule that documents, field warehouse receipts, can be perfected by possession. So the answer is yes. B. Assume the warehouse receipt is validly issued and effective if the bank and Kitty Delight signed a written security agreement covering the warehouse receipt and the inventory it represented, and if the bank gave Kitty Delight the money, so value is given, does the bank have a perfected security interest in the warehouse receipt even before the bank gets possession of it? So is there perfection even without possession? Is there automatic perfection? And the answer is yes. It was written into the code that when you create a security interest in a document, a warehouse receipt, there's automatic perfection for 20 days. And this was drafted in order to give additional protection to financiers, banks that relied on warehouse receipt financing, that they didn't want to worry that they would lose perfection because they didn't immediately have possession. So we give them this grace period where you have automatic perfection while you're trying to get possession of the warehouse receipt. And then it's a 20-day grace period, and before that 20 days is up, if you want to continue your perfection beyond 20 days, the bank would have to get possession of the document or file a financing statement. C. If Kitty Delight, prior to bankruptcy, wanted to get the warehouse receipt back from the bank in order to present it to the warehouseman, Mort, get the goods, clean them, and return them to the field warehouse, and then get the receipt for rehypothecation to the bank, will the bank lose its perfection if it turns the document over to the debtor? And the answer to this is no. There will be no loss in perfection. There's again, it's written into the code that if the bank has perfection and has this warehouse receipt, this document, it can give it back to the debtor so that the debtor can temporarily go in and access the goods, maybe make sure that the equipment is running properly, maintain them. If it's a machine, maybe oil them, do in order to keep the collateral valuable, do whatever is necessary for its maintenance. So giving it up temporarily does not result in loss of perfection. You can see that in 9312F, and it's just a, a temporary maintenance of perfection. And then D, if the bank loses its perfection, would you advise it to sue? I guess so, yes, of course you'd advise it to sue. Who would you advise it to sue? I guess you could sue everyone. I really don't get the thrust of this question. Would it be, it just would depend on the facts of the case. We don't have many facts to go on here. Let's just skip that one. Go on to 45. Octopus National Bank made a loan to Pi Solutions Incorporated, secured by Pi's patent on a solar-powered nightlight. Octopus National Bank learned that it is unsettled whether a security interest is perfected by filing in the state UCC office or the federal patent and trademark office. ONB had a brainwave. Rather than filing, can ONB perfect with a pledge by taking possession of Pi's patent certificate? Okay. This is intellectual property raises some complicated issues with respect to secure transactions, because there's federal law which talks about certain rights of different parties, like the rights of a buyer and assignee of intellectual property or patent right, and it even raises security issues. So there's this conflict between federal law and then the state UCC, and there's different case law about that. And best, whenever there's lack of clarity in that way, the best thing to do is to file in the state office under the UCC, and also do whatever you have to do under federal law, which is file a notice with the Patent and Trademark Office with respect to your security interest. Make sure that whatever court you get into, and whichever way they decide whether they feel that it's perfected under state law or under federal law, you'll be covered either way. But the important point to take away here is that this is intellectual property, a patent. It's a general intangible under the categories of collateral under Article 9, and you cannot perfect a security interest by possession in a general intangible. Well, that's what I want you to take away from this. So merely having possession of the patent certificate is not going to result in possession. You're going to have to file a financing statement and maybe file a notice with the Patent and Trademark Office. Problem 46. So Karate Incorporated was a self-defense training school, and it pledged 36 of the promissory notes given to it by its customers to Night Flyer Finance Company in return for a loan. Right? It provides these services. It's a karate school, and apparently the customers don't pay cash or by check up front, but they sign promissory notes to promise to pay in the future. And so Karate has these promissory notes, these obligations to pay, valuable collateral, and it's going to pledge them to the bank as collateral to secure a loan. And then if there's default, the bank can sell those promissory notes the market and make some money to recoup its loss. Okay, so the parties sign a security agreement. All right, and the finance, and I assume they've given a loan. So security agreement is signed, value is given. Debtor has rights in the collateral and the notes, so there's no problem there. And then the question of perfection is the finance company takes possession of the notes. Perfection arises. You can perfect by possession instruments, and a promissory note is an instrument. A month later, Karate Inc.'s president, Arnold Sun, asked Night Flyer to let him have one of the notes so he could present it for the customer for payment. The finance company gives him the note on April 6th. Sun, the Karate Inc.'s president, puts it in the desk at his karate school and forgets about it. And then months go by, and October 12th, the karate school goes bankrupt. And the question is, does the bank have a perfected security interest in any or all of the promissory notes? And you're directed in 9312G and H. The rule there is like the document, the warehouse receipt, where you could relinquish control temporarily for the purpose of maintaining the collateral. You can also give up a promissory note temporarily in order for presentment, so that the party can go and get the payment under the promissory note. And there's no loss of perfection, because you don't want the bank, on the one hand, wants the party to go ahead and have the promissory note paid, because the bank doesn't own it yet; it's just holding it as collateral. And so he wants to allow karate to go and get paid and stay in business. But at the same time, the bank doesn't want to lose the perfection and the security interest in that note. And so what the code allows is for the secured party to relinquish possession to the debtor for purposes of presenting and getting paid, and will remain perfected in that promissory note, but only for 20 days. And here the problem was that the president of karate put it in his desk and left it there for more than 20 days, and so there was a loss of perfection. And then the next question is, could the finance company have protected itself by filing a financing statement as to the promissory notes? And the answer is yes. You can, as is true in many cases, there are multiple ways to perfect a security interest, and with a promissory note, an instrument, you can either perfect by taking possession or by filing a financing statement. So file the financing statement. In addition to taking possession, there are reasons why you want to take possession, because there's a risk that a promissory note, and we'll talk about this in the future, there's a risk that a promissory note, if you don't take possession, will be negotiated to a holder in due course who doesn't know anything about the secured transaction, and that holder in due course can then take priority. So that's one reason why you want to take possession of the promissory note, so it's not sold to someone. At the same time, it's wise to also file a financing statement in case a situation like this arises, where you relinquish it temporarily and then it disappears. It's put in a desk for a couple of months. You would lose perfection under the possession method, but if you had a financing statement filed, you'd be perfected. Now, that has nothing to do with possession. So again, best to do belts and suspenders. Take possession, file a financing statement. It doesn't require that much, it's not expensive, and it gives you that added protection. Okay, that's the end of this assignment, and I'm going to get on to the next one shortly. See you soon.